Good afternoon, everybody. Thanks for joining us and sticking around till the end. My name is Chuck Jaffe. I'm a financial journalist and talk show host, and I am the host of the Navigator podcast, which is the Active Investment Company Alliance podcast, which we produce each week. This is Industry Track Panel 9. It is Activism in Closed-End Funds. I have a very diverse panel here. I will spend some of my time moving out so that I can actually see them, because the hardest job may be reining them in on this one. But there's a lot to talk about, so we're gonna dive right in. But first things first, I wanna point out, I'm not an expert in closed-end funds. These guys are. So I'm gonna do my best to get out of their way and let them go at it. But believe me when I say that we can fill this time without questions from the audience, but we want to make sure we get your questions. So while we're gonna try to leave some time for the end, if you've got a question, you want to get it to me, feel free to write it down, get it passed over to me, walk over, I'll be here. And if you've got something that we can add in earlier, be happy to include that. Now this panel represents 4 very different roles within the industry. As a result, they have very different perspectives on activism and closed-end funds, which should keep things lively. So here's the 10-second intro on each. Mike Taggart is closed-end fund specialist at Aberdeen, which basically has him in the investor relations role, working on the company's North American closed-end funds with all shareholders. Ron Mass is managing partner and chief investment officer at Almatas Capital, which is an RIA firm. He provides investment management services to institutions, high net worth individuals, family foundations, and more, investing both domestically and internationally, and the international will definitely be coming into play during this discussion. Brian Schaefer is a partner at Prosec Partners, where he provides investor communications counsel to senior management and board of directors, helping them through special situations, including proxy contests, takeovers, and more. And Aaron Morris is a partner at Morris Kandinoff, which represents investors and institutions in all manner of corporate governance cases. Gentlemen, to start your engines here, I want to throw out a number. In May of this year, the Investment Company Institute issued a report which showed that a record number of traditional closed-end funds were under pressure from activists compared with any year back to 2000. ICI's president said at the time that activist investors' disruptive tactics are damaging the sector in pursuit of their own short-term profits. I will point out the irony in the idea that the ICI represents fund companies whose tactics, taken in pursuit of profits, sometimes damage investors and often lead to activism. Still, is today's activism mostly the same kind of thing that closed-end funds have experienced historically? Or has activism devolved into a series of basically arbitrage play? Is there a difference between arbitrage activism and the rest of activism?
Well, I mean, if I could start, if you don't mind. So I do think it's a good, you've opened up a kind of a good point, Chuck, that, you know, we like to talk about activists, right? And there's a spectrum, right? So on the one hand, or kind of on one end of the spectrum is, and I'm gonna plagiarize here, I hope somebody sitting up here with me doesn't mind. On the one hand, you have longer term investors who are more suggestivists, right? So they're investors who make suggestions to management, but they're longer term investors and they're very smart. And then kind of along the line, you have long-term investors and, you know, I mean, they actually perform due diligence on your funds, and some of them are in the audience. And they do their annual due diligence calls and that sort of thing. And then kind of at the other extreme, you have large investors who may actually hedge out their underlying positions of the funds that they're in, and once they achieve their objectives, they're out of the fund within 3 months, and or as the data shows, typically out of their funds in 3 months. So, you know, there's a wide range of what maybe the fund industry just kind of says, oh, these are all activist investors. And, you know, I think there are nuances in there, and maybe the industry should be a little careful how, you know, when we're painting with such a broad brush of how we label people or firms. Because I think sometimes by doing so, we're not really doing ourselves a favor by doing that.
I would say that, I think an activist is an arbitrager, and that they're looking at the calculation. If they can buy a fund at 15% discount or 20% discount, they can accumulate enough of it, and then they can force some type of action. We're always doing the calculation. While we're not an activist, as Mike mentioned, or a suggestivist, we like to try and have dialogue with funds and suggest things that might improve corporate governance for everyone. I think an activist is looking at that calculation. We're looking at that calculation because we're trying to see, should an activist come on board, what would happen, how much the discount would likely narrow, how long it would take. And so, I think that's the way an activist thinks, is that, what's that profitability? What's the odds? What are the legal costs? What's the time frame and all that? I mean, maybe Phil Goldstein, maybe since I'm not an activist, but we are being pushed to do activism by our client base, who's seeing the tremendous results of some of the activist investors, and are asking us if that's something that we should consider and add to our tool belt. So it's always a dialogue with our investors, but maybe I should sit down and read some research, and Phil should come up and take my place.
He was up here last year, so.
I appreciate the nuance that Mike points out, I think, but in reality, the vast majority of activism is practiced by a small handful of activists themselves, right? It's Saba, it's Bulldog, it's Carpus. And when you think about the fact that Saba in particular has filed 238 13D and amendments year to date in 2024, that's not a constructive investor. That's an arbitrage investor. And by his own admission, he is an arbitrage investor. So I think we have to look at it based on what they're telling us and based on what they're doing through their own filings and certainly in their own actions and what they're pushing for in their agendas, that, yeah, they're activists and they're having long-term harm on the industry. The last panel talked about the fact that, there's 20% fewer funds over the last 5 years and 30% fewer funds over the last 10 years. And that is not because of mergers. There's only been a small handful of mergers. The majority of these funds are getting pushed to open end, pushed to liquidate by this small group of activists who are practicing an arbitrage strategy.
Right, but I would argue that, right, they're one end of the spectrum. They're one end of the spectrum, and I think everybody would agree that they're considered an activist. But I would also argue that some people would consider Ron to be an activist, where I would argue that Ron is not an activist, right? So, like, there's a spectrum.
But there's fewer Rons than there are, or fewer.
I would argue
right,
but I would argue that there are way more Rons, right? But those folks get lumped in with, like, oh, they're evil activists, right? And no, they're just concerned shareholders, right? But yeah, at the other end of the spectrum, yeah, those are short-term arbitragers.
I just think the barbell is a little bit more weighted toward the professionals than the Rons of the world.
Well,
so to speak.
Just not to digress too much, but if I go back to the UK 25, 30 years ago, firms like Elliott were in the UK with activism when they had wide discounts. And what the industry decided to do is make a lot of changes in response, a lot of constructive changes. And I think activism can be a good thing because it's, I used to be a portfolio manager managing closed-end funds, and I always felt guilty if my fund trades at a discount. I have shareholders who back then were paying a premium to NAV to buy my shares, and then that fund goes to a discount, and they've been harmed because they've lost money because that fund went to a discount and the board didn't do anything about it. And in the UK, the Elliots of the world and others were very aggressive, Carousel, and you had a lot of other names that many haven't necessarily heard of, but the industry decided that they needed to put in some better practices, discount control mechanisms where funds institute buybacks if discounts reach a certain level, conditional tender offers where they have continuation votes where shareholders can vote every few years of whether to continue. And they also change practices of directors where a director shouldn't be on more than a certain number of boards. They shouldn't chair more than a certain number of boards, and they shouldn't be on a board for more than 9 years and be considered independent. And what happened is discounts narrowed. You saw a lot more funds. The UK market used to be smaller than the US market. Today, the UK market is actually larger in market cap than the US market. It's been more vibrant. I think the reason is because the industry cleaned up their act and decided to have more independence of directors and better corporate governance. And I think the challenge in the US is that funds have resorted to more legal means to stifling investors rather than taking steps, positive steps. Although I will say in the last year, there's been tremendous positive steps, increased share buybacks, conditional tenders, some of the things the earlier panels were talking about, higher distribution rates, things that help the funds trade better. And, on the earlier panels I talked about, I think that's a tremendous positive step. Firms like BlackRock have bought back, millions and millions of shares, which has been very accretive to investors. So I will say, I think things are getting better, but it's a real, I think you have to think about what's the root of the problem, not are activists good or bad, or are they destroying the market? It's what are the funds and the directors doing to protect investors?
Yeah, Ron, I think it's a good point to note that the activists in the US, everyone in this room knows the fund boards are weak in most cases. And then the activists really supplement the pressure that I think personally the fund board should be applying more than they do. And if you don't have a fund board that's actively looking at discount, actively looking at performance, and actually doing something, and most of them aren't until someone shows up on their door, you need someone to show up on their door. And at the end of the day, activists are just shareholders who are getting out and actually doing something. So I think it's important in the U.S. market to have vocal shareholders that will hold the management accountable.
I think that's a little bit of a misnomer. I think this idea that the fund boards are sitting on their hands, they're not actually trying to put initiatives through, and look how many that get blocked by activists, whether it's a fund that's a term fund that wants to continue as a continuation fund, a perpetual fund, excuse me, and it's outperforming, and it's, all of a sudden you have an activist trying to block that, or you have fund mergers that the funds want to put through that the activists are trying to block. At the same time, though, you talk about weak boards at the fund complexes, but then you look at the nominees or the quality or really the lack thereof that the activists are putting forth. And in some instances, it's almost a mockery. You're seeing family members, grandsons, son-in-laws being nominated with no experience to sit on a board. And so, if you had quality candidates and people who wanted to work with the boards, like you see in operating companies, you mentioned Elliott earlier, somebody had mentioned Elliott earlier, when Elliott goes after a company and they nominate directors, they usually nominate CEOs of former competitors. They're not nominating people with absolutely no experience. So, I think it would be great in theory if they were holding people accountable by putting up quality candidates, but we're just not seeing that.
I think, to be intellectually honest, some of these, it doesn't matter if you put up Bill Gates. You'll never see a fund board say, oh, come on in. I've never seen it. And in some of the funds that are being targeted are the lowest hanging fruit. You could put a monkey up and shareholders would vote for them because the discount's been so bad, the performance has been so bad. It's not about your credentials at that point. It's about who's actually going to do something, because this fund board's not going to.
I would argue, though, that, when you look at some of these large fund complexes, they have directors that are sitting on 50 or even 100 different boards. They're getting paid $500,000, in some cases over $600,000 a year. And that's a pretty good job to be retired and get a bunch of free donuts and coffee and sit in a handful of meetings every quarter. Maybe you have to go to monthly meetings or monthly calls, but still 600 grand's not a bad job for, for someone to do that. And, if you're getting paid that much by a large fund complex, then, how independent really are you going to be? If you start to upset the apple cart by saying, hey, we should change this, or we should buy back shares, which will, aggressively, which will lower management fees potentially, I think they're in a real quandary because that conflict of interest that they're on so many different boards. And I just a plug for Aberdeen, they tend to have much more diverse board members that, where they're not on 50 boards. They tend to pick much more diversity of their boards as opposed to someone that's on 50 or 100 different boards.
And so I have 16 funds and 9 boards, and every 3 months I have to report to the 9 boards. And after 3 days, I'm kind of just a wreck. So
Wow, that's a lot of free donuts and coffee.
there's not much free donuts and coffee. And
Let me jump in.
Well, good governance isn't always easy.
Well,
So-
to like your point about they just kind of skate through things. That's not my experience. I just basically go home, and I won't admit in front of these people that I cry in my pillow for 2 subsequent days. But
Let me jump in here for just a second, and I will point out that as somebody who's been covering the closed-end fund business for more than 30 years as a journalist, that when I was first talking to John Colescott's father and learning about closed-end funds, that was a time when the public, the investor, saw activists as wearing the white hat. And now they don't necessarily. And that, no matter what you want to say on it, is still one of the biggest issues, et cetera, in terms of how the public perceives closed-end funds. But now I want to move and kind of show how each of you is impacted by activism in your roles. I'm going to start with Mike on this one. Mike, as you help guide Aberdeen in its closed-end fund strategies, is activism in any way, shape, or form impacting the decisions you make about what you're going to offer, and how, if at all, does it impact the investors that you deal with? I mean, since you have both sides, you're dealing with your fund boards, but you're also the conduit to investors.
well, I don't think we deal with investors. I've been in this role for 14, 15 months now. I'd always kind of, I've been looking at closed-end funds since 2010. I was always kind of intrigued by the way Aberdeen went about its business with interacting with its investors, because they proactively engaged with, all of their investors. And I thought that was interesting that they proactively engaged. Like I met, and he may not remember this, but I actually met Phil Goldstein when I was at Morningstar. Aberdeen sponsored a webinar where it was 3 of the largest activist investors. So it was a webinar, and I was at Morningstar, so they had me moderate it here in New York. It was Phil, Barry Olaf from City of London, and a guy from Western, and I moderated it. And I thought, well, that's interesting. Why would a fund sponsor do that? I still don't know. In my role, we proactively engage with all investors. And it's interesting when I call on people for the first time, advisors, they don't understand what I'm doing. I think they think I'm a wholesaler, and I'm using the closed-end fund hook to try to get in to sell mutual funds. So we think it's important to proactively engage with our investors, and that includes the activists. So not only to kind of do classic investor relations stuff, but just so that they know that there's actually a point of contact for them, so that when they do their annual due diligence meetings, they have a point of contact, and I can organize the portfolio managers and make sure that we have a presentation ready for them. And anytime they have a question, they can reach out to me, and I can get an answer for them if I don't know it off the top of my head, to get it back to them quickly. And just have an ongoing dialogue and make sure that we kind of meet face to face at least once a year and that sort of thing. So, and if they have concerns, I can turn around to product and let them know. And then obviously at the quarterly board meetings, let the appropriate board know that the that investor, whether it's an activist or anybody else, know that concern has been raised. So
Let me move this to Aaron. Aaron, as an attorney, my judgment of an attorney, you get paid to worry about every possible permutation of activism that comes down the pike. There are a lot of issues happening right now, from the New York Stock Exchange's proposal to eliminate board annual meetings for closed-end funds, to the recently resolved case in Massachusetts where I live, which saw the court reject Saba Capital's challenge to the standard voting requirement that a majority of outstanding shares is necessary to win a contested election for a board of directors and more. But which are the hot button issues for you right now? Not the ones that are maybe getting the headlines but aren't going to happen, but which are the hot button issues in activism for you?
Well, you just listed a lot of them. We could talk all day. Some of those have kind of run their course. We saw control share litigation run its course. And at this point, it's pretty clear you can't use a control share bylaw. There's a petition in the Supreme Court. It's not going anywhere. So that's kind of run its course. Maybe what's hot now is the issue we saw teed up in the Eaton Vance trial, whether or not you can use a majority of the outstanding voting standard for a director election. Pretty interesting result in that case. And then the pending poison pill litigation involving a BlackRock fund. Maybe those two, I'm watching the closest. The NYSE proposal to eliminate annual meetings for closed-end funds obviously would be a silver bullet, but it doesn't seem like it's going anywhere based on what we saw recently from the SEC. They're gonna apparently further consider the potential disadvantages. Seems unlikely to me that an investor protection organization is going to remove an annual meeting requirement that we've had for decades and that we rely on to engage with management. So maybe really it's the vote standard and it's the poison pill. And we should talk about Eaton Vance because it just happened and it's an interesting ruling.
Yeah, I don't think the poison pill is as impactful. I also disagree slightly in the sense that I don't think the New York Stock Exchange rule should it go through as any form of a magic bullet or silver bullet, however you defined it, solely from the fact that a number of fund complexes still have it in their charters that they have to have annual meetings, so they would have to go back and get the vote. And the reality is, yes, it would have an impact on new listings, but the idea that annual meetings for all funds would go away. At the same time, though, yes, it is something that's been in place for decades, but closed-end funds, as you're well aware, are the only registered investment company product that has annual meetings. Mutual funds don't have them, ETFs do it, so we're held to a different standard, and I think we can agree on the implementation and why that is, but it doesn't mean that's not something that should change either.
The timing is interesting, right? Like closed-end funds introduce more issues that you want to engage with management with because of the liquidity, because you have to get out at a discount in poorly managed funds. To take that venue to engage with management away, especially right after the industry lost control share, we see what's going on.
You can still call a special meeting, and as Mike will attest, you can still have investor relations. You can still go out and talk to your investors, and you should. The idea that you should disenfranchise an activist, they are a shareholder at the end of the day. Like it or not, they are a shareholder. So you should not disenfranchise anybody. So you can still have that dialogue, and if they still feel compelled to bring action against a fund, then they can call a special meeting and then try to exact that.
Phil can tell me if a special meeting has ever been called, but the standards are usually high. I mean, it's at least a majority of outstanding. So they're just not comparable ways to be able to exert influence over management of a fund, which is key in closed-in context.
But I think you also have to look at the advantage of doing away with the annual meetings, and that is the fees. Those are substantial fees. Are they? They are, yes, they absolutely are. There's a lot of data out there that will suggest that.
You've got the scale of justice here, and you're talking about a 5 or 6 figure number versus being able to engage with the managers of your fund. I don't know about that equation.
Brian, as the follow-up again, if I'm representing the consumer, if I'm representing guys like Rich in Orchard Beach, Maryland, who invest in closed-end funds and write me all the time, their problem with some of the things that they see is that it's not that difference between is it white hat activism, black hat activism. It's that when you start to talk about eliminating annual meetings, it looks like you're going to a place where it's lawless, where it's just getting that much more Wild West, not less Wild West.
I think that's more of an optics issue than anything in reality. And I don't think that if you do away with annual meetings, that boards are all of a sudden going to go rogue and start, quote unquote, misbehaving or do anything of that nature. They still have a fiduciary obligation at the end of the day. They are still bound by the 40 Act. You still have to have, as a result of the 40 Act, an independent board. So you're still going to have a lot of those checks and balances in place. You're just going to do away with the annual meeting requirement itself.
I would question, though, the boards and how independent they really are. And it was enlightening to us when 15 years ago we started investing in the UK. And if we would buy 3 or 5% of a company's shares, we would actually have the board reach out to us and introduce themselves and ask how we feel about the company and ask if we want to talk to them. They'd usually want to talk to us without the manager present because they want to understand their shareholders and understand their views. And when we tried to reach out to board members of funds, if there's a fund that historically is trading at a wide discount, has had poor performance, and we're concerned about it, we've asked to speak to board members. More often than not, the answer that comes back is the board doesn't speak to shareholders. You need to speak to your manager. Well, in that case, the manager's the problem. I mean, I'm talking about the more difficult issues. There's plenty of funds where the managers are doing a great job and there's no issues at all. But in those periods where you have funds that are performing poorly, that aren't taking steps to address the discount, that are producing poor share price and NAV returns, the protection to the investors, the independent board, and the independent boards often in the US behave very differently than countries like the UK and Australia in their closed-end fund markets, where they really want to engage, they want to listen, and they'll take direction from the shareholders. If a lot of shareholders want something to happen, they'll put it in place, whether the manager likes it or not. In fact, you even see, you've seen cases where one manager has underperformed over years, and the board terminates that manager and changes the name of the fund to reflect the new manager. So, instead of having a PIMCO fund, you might replace it with an Aberdeen fund.
There we go.
Yeah.
I was about ready to cut your mic off until you said that.
I think that's the core issue, Ron, is and more about international markets where you have that dynamic than me, but in the US, no one in this room wants there to be real competition at the contract level, and there isn't, right? You will never see that type of change in manager unless it's an advisor-driven transaction. Where if you saw that kind of competition at the contract level, if you had a board that actually said, hey, we might hire someone else to manage this money, it's never going to happen. I've never seen it happen. Maybe Phil can remember a time. If you had that dynamic and you really had independent boards putting that kind of pressure, I think you'd feel differently about the extent to which shareholders needed to directly engage.
I don't disagree with you. At the same time, we have seen it when activists have taken over boards and they've ran a quote unquote process to evaluate who should be the manager. They don't disclose who they considered, and lo and behold, they magically appoint themselves. So, all of a sudden when the shoe's on the other foot, it's okay, we can do what we want with it. We've seen this in other funds too, and they're like, we'd like to let everybody out, and they do a tender and they let themselves out, but they still trap everybody else in a fund with a different investment objective. So I think it's one of these things where it's a great rallying cry until you take control of the fund, and then all of a sudden you do the exact same things that you railed against. And we've seen this in at least 4 instances when activists have taken over funds.
What's wrong with solving the problem with just having better corporate governance? Like some of the panels earlier were talking about, maybe closed-end fund 3.0, where you have conditional tenders every year if the discount's wider than a certain level, or the funds will are required to buy back shares if the discount gets to double digits. Wouldn't that be a better solution? Because then you'd have narrower discounts. The fund management themselves can say all the great things they're doing, how much value they're creating, And if discounts are narrower, wouldn't it be better for the market overall? Because then you'd see a lot more funds created in good times.
Of course, and I think a lot of boards do have those types of programs in place. Tender offers, in my view, though, are, especially the smaller ones, the automatic triggers of 10% are really death by 1,000 cuts, because all you're doing is weakening the asset base. But certainly buybacks and other things like that are effective, and those things, they are in place today. So, does every fund have that? No, but a majority of them are looking at these types of things and have them in place.
The question is, in an alternative universe with no activist pressure, how pervasive, or you see the sequence, an activist shows up and now you've got board action. And that's kind of what you want to see, right? How much independent board action would you see in the absence of pressure?
Well, but shouldn't part of the question be, if we're talking about a world in which activists have a role, shouldn't the ultimate decider be that if closed-end fund world is a meritocracy, you survive on your merits, which ultimately, in at least many activist cases, they're suggesting you don't deserve to survive on your merits. So isn't that a process where somehow that should be decided?
Well, I think in that instance, it comes down to how do you actually measure that performance? And I think there's, certainly discount to NAV is important, right? But I think people over-index on discounts. If you're buying a product that is designed to perform over multiple market cycles and you try to apply a 1, 3, or 5 year viewpoint on it, it's going to underperform. And if you look at an asset class like munis, and last year you had essentially 48 different muni funds being attacked by activists. If activists had their way and those muni funds went away, they would have all missed out on the upside year to date in 2024. And most of those funds, or the average of those funds, is doubling the Bloomberg bond index. So you would have taken away an investment vehicle, you would have taken away a retiree's money, essentially, their income, if you just did away with munis because they had traded off in a high interest rate environment. And so I think when you look at it, the effectiveness of activists, you have to look at it over who is the product designed for, what is the time horizon of the product, and is it doing what it's supposed to be doing at the end of the day, meeting its investment objective, and returning distributions. Distributions is where the focus should be. Not on, is it a short-term discount trading to NAV?
Yeah. Does that ultimately mean that the activist is not basically representative of the shareholder? In other words, if I took a closed-end fund and we said, here's this muni fund, let's take a look at our shareholders, let's take a look at who's being activist, and I recognize that the individuals maybe don't have as much money as the institutions do, but in terms of plurality, who's got people in there, that we're basically saying that the activist investor no longer represents, they represent their position, but not the bulk of the money that has picked that fund for that investment?
I think the answer is no. And I'll give you just one example, going back to last year's BlackRock fights. There was 2 decks filed related to ISS. One was a supplemental deck. In that supplemental deck, BlackRock disclosed the negotiations they had to reach a settlement with Saba to end all of this. Nowhere in what Saba was asking for was the word governance. All they wanted was to get their money, take it out of the fund, and go home. The idea that there's alignment between activists and retail shareholders in most instances, I certainly won't say all, but in many, if not most of the instances out there, are not aligned. They are acting in their own interest in that instance. And you can see this when you get to the negotiations, what they really want at the end of the day. They don't want improved governance because they don't want to stay in the fund. They want their money and they want to go home.
Well, see, and that's where I would go back to my spectrum thing at the beginning. And I would say at the far end of the spectrum with the Sabas, where you're talking about, arbitrage and those sorts of activists, I would fully agree. But on the other end of the spectrum, where you're talking about longer term shareholders and people who don't hedge out their underlying positions, I would disagree. And that those investors would be aligned with other, retail, like more retail investors or advisors who are in the funds, in that they do have, they want the funds to continue longer term. They want the funds, to be, to fulfill their investment objectives and to continue on to hopefully perform well, and that sort of thing. So there is a nuance there that we can't just say, well, everybody that we consider to be an activist kind of pursues the same course as Saba.
I can maybe one up both of you. I have a magic test that can actually answer your question every single time. And it's a vote. It's a vote. And we figured that out, you know, we based our democracy on that idea that you just hold a vote. And we don't really know who are in these funds. You know, the industry has latched on to this idea of this hypothetical long-term shareholder that is loving the current manager and never wants to change it. And the worst thing that could happen to them is someone come in and change control. We don't know if that person exists or not. And the only way we can test it is to hold a vote. And we've spent a lot of money and a lot of intellectual brain power coming up with ways to manipulate the vote, to prevent the vote. And someday you might as well just let them decide for themselves.
But even when you have the vote, you don't know because, you know, people who own the shares don't vote. So,
If they
don't vote, they have voted.
Right.
Folks, we have some time for Q&A. If you've got questions, let me know. I ask one question.
Except for him.
I ask one favor, which is please identify yourself before you ask the question so that everybody else knows who you are.
So is it the answer to this question, right? Full vote, okay? Like, why can't you get a majority of the outstanding shareholders to vote for what you say is in their interest? So spend the money and solicit and get a majority of the outstanding shareholders to vote for what you want. And then the shareholders have spoken. That solves every problem up here. It solves the annual meeting thing, it solves the e-advance thing. Just go solicit and get people to support you.
Are you talking to, is that to me?
I think we can all answer.
You talking to me?
The reality is, the solicitation happens. The solicitation happens. The letters go out, the get out the vote, the reminders. If it's non-contested and we're allowed to actually call, you know, and that's a Broadridge issue we can talk about all day, but the effort is there to get the vote. And a lot of times they're pushing out the annual meeting date, right, trying to get to quorum. They continue to do that. It's in everybody's interest to get to quorum. They're trying to get to that point. They're just not able to because you do have, sort of, you know, we obviously have to differentiate between objecting beneficial owners and non-objecting beneficial owners. But in terms of the latter, it is a Herculean effort to get these people, to reach them, to get them to vote. But the effort is being made.
Yeah, well,
Isn't that your investors saying what happened?
Well, I think what we saw in Eaton Vance is there's almost no precedent for reaching that vote threshold in closed-end funds. The attorneys came up with, your former colleagues did a good job of scouring the data, and they found 2 instances where a trustee election met that threshold. But there were no instances in the past 10 years of any peer fund to those funds. Certainly the funds themselves have never come close to meeting that. So it looks to me to be what would be an impossible standard. The judge disagreed in Eaton Vance. And, you know, maybe there is some feedback to take from that opinion. You know, she did take note that the activists didn't engage with the retail investors to the extent they could have, didn't make phone calls, didn't do the kinds of things that Brian just listed. So maybe there is some fair feedback to take from that, but I think we all know that's an incredibly difficult standard to meet and would certainly work to the advantage of the incumbents always.
Let me stop you there. Got time for one more question if somebody's got one. Phil Goldstein, you get the last one.
So in my more powerful belief that problem was that funds that were part of the common way of activism was not so much the discount, but the lack of accountability. And that with an open-ended fund, obviously opponents for reductions go up. AUM goes down, fees go down, everybody gets the message. The closed-end fund, as you know, no supermajority voting requirement that makes it virtually impossible to hold, to replace the board, eliminating annual meetings, meetings tactics that essentially entrenches the board for life. You know, you can talk about fiduciary duty, but what does that mean? And how do you really, you know, you sue the board for violating its fiduciary duty because it's performed, it's underperformed its benchmark for the last 20 years and it's trying to get a 40% discount, and they know what the board to say, oh, business judgment rule. So what is the accountability mechanism that the investor can have to hold the fund accountable? I mean, there's a fund, just I'll finish up. It's first-hand technology fund. I mean,
I am. I've covered that story a few times.
What, $20 anything or a nickel? They were actually the market price of the fund, the market cap of the fund is less than the accrued management fees that they've been able to pay because they have cash. They don't have cash, so the board has been completely remiss. They have a 50%, actually somebody did for a
They've got a majority of outstanding standards, so they've kept that fund and run it into the ground.
the vote was what was this supposed to like 10 to 1?
Phil, I got to cut you off because I want to get, I don't mean to, but what's the accountability?
What's the accountability mechanism?
Yeah.
The accountability mechanism is the performance of the fund in relation to its investment objective. And if it's not meeting its investment objective, we've seen this time and time again, where if there's not action taken by shareholders, you will see the funds themselves either voluntarily open up, they will voluntarily liquidate, they will look for other opportunities for mergers. But the idea that I think that they just run on in perpetuity in gross underperformance and, you know, if you want to say, you know, dereliction of their fiduciary duty, I don't think that happens. In some instances, does it happen perhaps longer? And should somebody have stepped in earlier? I think you can make that argument. But this idea that, you know, the funds will just run rampant and continue to underperform and the discount continue to be there for longer periods of time, I don't see that.
Well, how often in the U.S. has a fund underperformed where the board took action, such as terminating that manager? If that manager underperforms for a long period of time, have we ever seen a case where the manager was terminated by the board and they selected another manager? I think that's incredibly rare. And you have many funds with periods, you know, money funds have outperformed their benchmark, but you have a lot of examples of funds who have underperformed for 1, 3, 5, 10 years, and yet the board takes no action. That's why I think, you know, maybe, you know, closed-end fund 3.0 needs to have automatic measures such as, you know, required buybacks at thresholds, things that are accretive, that were long-term, you know, to be the benefit of shareholders, and will keep, you know, the discounts in check. Because I also don't like the idea of, you know, in the proxy, I get calls all the time, there's a proxy fight and your board recommends that you vote with the choice of the directors. Well, you know, why should I be having the fund pay my shareholder money for people to call up and say that you know, soliciting a vote saying that the board recommends that I vote with them, when, you know, that's potentially the problem in itself, is the board's not taking action.
I'm going to cut us off there because we have it at a good spot where we're talking about what would happen with Closed-End Fund 3.0. That, I am sure, will be a topic for another discussion at another convention, conference, and I wholeheartedly encourage you to come back to that. I'd like to point out there's a cocktail party coming. I think drinks are on Mike Taggart, or at least they're on Aberdeen. So please,
Aberdeen.
please make sure if you like what Mike said that you celebrate with him, and if you dislike what he said, drink heavily. And thank you, gentlemen, for doing this. This was great.
Thanks, everybody.